2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Before Mr. Hivner calls the case, just a brief note that if we should have some unanticipated technology-related problems, everybody just take a deep breath and pause, and we'll work through it and resolve it and then proceed from that point on. Mr. Hivner, call the case, please.
Estate of Marybelle McGraw Marlin versus Harry Whitehead Marlin III et al.
Brief note that if we should have some unanticipated technology-related problems, everybody just take a deep breath and pause, and we'll work through it and resolve it and then proceed from that point on. Okay, let's hope the time isn't quite that.
McGraw Marlin versus Harry Whitehead Marlin III et al.
That's very strange.
Yeah,
Like
Nick.
there's a time delay that's
Yes.
I believe someone has the volume turned up on their computer.
If you all will put yourselves on mute, I think that will help us to
Yeah.
resolve that issue.
I'm not sure what's going on.
As I said, we don't anticipate any technology-related problems.
Strange.
Yeah, Nick.
Time delay. That's
Yeah.
I believe someone has the volume turned up on their computer. Yeah, it's Mr. Schwegler. Mr. Schwegler, do you have YouTube open on your computer? You can unmute yourself if you need to talk to me. I muted you so I could see what was going on.
Does that help?
Did you have YouTube on up?
I think I did.
Yeah. Did you X out?
I did.
All right, perfect.
Good. Thank you, Nick.
Yep.
Now we're ready to hear from the appellants. And I understand the two of you have divided your time up.
Yes, Your Honor. Thank you. Mike Schwegler of the Nashville Bar for appellant Harry Marlin III. I'm going to refer to him as Harry today because all the parties have the same last name.
Understand.
This partition case involves a farm property with developable portions, some of which are or may be worth much more than other portions, and has a long history dating back 20 years to the admission of the decedent, Mary Marlin. I'm going to call her Mary. Her holographic will in solemn form in February 2002. Holographic wills, of course, tend to create legal issues. And the legal issue here is the phrase, quote, equal acreage according to the attached survey, unquote. And the issue arises because there was no survey attached to the holographic will. Without the survey, Mary's intent is not known. In this partition case, the trial court's decision did not include the value, the economic value of the 3 tracts it created in the probate of the estate of Mary Marlin. Had 3 results. First, it created 3 inherently unequal tracts of land. We don't know how unequal the tracts are because the court denied my client's requests, multiple requests, to have the tracts appraised for value. Harry's and his siblings' tract has a gas line easement, the least amount of road frontage, 2 graveyards, and substantial portion is in the floodplain. We have not had the opportunity to evaluate the impact of those encumbrances and characteristics on the value of the parcel. In fact, if you look at the timing of the hearings, the special commissioners issued their report on November 30th, 2020, only 1 day before the trial court's final hearing and 14 days before the court issued its order approving the partition. Second, fundamentally, the court redrew the boundary lines, and rather than identifying the testator's intent, it substituted its own judgment. This was a partition case. Procedurally, it's unusual in that it was adjudicated in the probate court, but it still was a partition case. And as such, the third consequence was that the probate court effectively picked winners and losers because the record reflects that the testator sought an equal division of her property, not just equal acreage for each child. In addition, although this case proceeded in the probate court by its own admission was conducting a partition of property, and therefore should have applied the applicable statutory requirements which call for equality. And those statutes are, I think, briefed by both parties in our briefs. The trial court itself said that the original 1975 will which was executed by Mary and her deceased husband, that, quote, the court said that Mary, quote, wanted her children treated equally, end quote. And the executrix, Linda.
Counsel, let me ask you the earlier will, the 1975 will, was not that phrase you're talking about, or we're trying to talk, didn't apply to just real estate, did it? It covered everything.
I believe so. I believe that's correct, Your Honor.
And the codicil just applied to talked about the real estate. Is that right?
I believe so.
Okay.
Linda, who is my client's aunt and is the executrix, she said the same thing. She said that her mother's goal was for the heirs to be treated equally. In late 2019, early 2020, Harry filed a motion to alter or amend, asking that no further new survey be obtained. This request was denied. So we went through, and approximately a year later, at the end of 2020, Harry tried again with the request that appraisals be conducted for all three of these new subdivided parcels out of the farm property. That was also denied. Similarly, also in late 2019, early 2020, Harry's siblings, his sisters, asked that the case be transferred back to Chancery with the simple conclusion that the 1996 survey should not be included in Mary's will, or thus considered in the partition. That was also denied. Procedurally, I think that the case should have been sent back to Chancery for a strictly partition proceeding rather than this mishmash of probate and partition situation, which is what we ended up with. And when the court adopted the special commissioner's findings without relying on the equality provisions that the statutes and cases require, it substituted its own judgment rather than tracing and tracking down the testator's intent. My client, Harry, believes that this court should either remand the case with an instruction to include the value of each new parcel or and make sure they're equitable, or with an instruction to sell the entire undivided farm property. Thank you.
Thank you. Next. Ms. Watson, you need to unmute your computer.
Thank you, Your Honor. Sorry for that.
Not a problem.
I represent two of Harry Marlin's sisters. Their interests in this case are essentially the same as those of the appellant. And as Mr. Schwegler has shared, this is a matter that's been lingering for more than 20 years now, after the death of Mary McGraw Marlin. Her three children went for a number of years and were unable to divide the farm based upon the language in the holographic will. It was after Harry Marlin Jr. passed that the original partition suit was filed in Chancery Court, which was then sent back down to the probate court. In this probate court proceeding, we have moved as if it were a partition proceeding. There were commissioners appointed. Those commissioners were very qualified. I think everybody acknowledged that. There was a surveyor or civil engineer. There was someone with real estate experience, and there was an appraiser. But the court directed that the property should be divided in equal acres following the language of the 2000 holographic will, although the court did acknowledge that it did not revoke the prior wills, and that included the 1975 will, which specifically said that the estate was to be divided equally.
Mr. Watson, I'm sorry for interrupting, but after the court ordered the property partitioned and it was, how did the court determine who got which of the three different parcels?
What at the hearing, there was discussion about the presentation of drawings, which the court rejected. The court found that it could not unequivocally conclude that the offered exhibit was the survey that was referred to in the holographic will. But then the court proceeded to take into account drawings that perhaps had been discussed in the negotiations and the testimony to indicate that the 3 tracts were to be allocated to the specific interest there. Raleigh Martin would be receiving the tract that was adjacent to a property where he had built his house, which made sense. The middle tract would be allocated to Linda Marlin West, and then the remaining tract would be divided among the 3 children. And so that's how that was determined. But it was based upon drawings that had been discussed over the years, although the court concluded that there was no drawing that would rise to the level of being admitted as an appropriate exhibit and part of the holographic will.
All right, let me ask you a question, counsel. But I mean, one of the things she stated in there, divided in equal acres. So that's, according to the division I've indicated on the survey. So apparently she was talking about some division that would divide it in equal acres.
That's correct.
So what do we do with the phrase equal acres? It sounds like your clients and the appellants, all the appellants are talking about really, you might well have a very unequal division as far as acres.
Well, I think we could have an equal acres division that also considered value. It might adjust the property lines in a different way so that each of the 3 tracts would be in equal acres and have equal value according to the opinion of the appraiser. But the court directed that the commissioners did not have to consider value of the tracts in the division, that they would just consider equal acres. And our contention was that when you couple the holographic will with the prior will, which included equal acres and equal value, the value should have been a consideration.
Thank you. The appellants have your time for rebuttal. We'll hear from the appellees. The appellee. I believe you need to unmute your computer.
I was attempting, my mouse was not cooperating. Sorry. May it please the court, I'm Rod Scott, and for the purpose of this hearing, representing Raleigh Marlin, Linda West, and the estate of Mary Marlin. First, let me clarify something. This is not a partition case under the statute. This is a will construction case. Nowhere in any documents involved in this case is there a statement by the testatrix that she wanted equal value. She said equal acres. She said that in her codicil of August 24, 2000. She said that in a drawing known as Exhibit 4, which was a survey drawing that has her handwriting on it, which stated boundaries between Linda and Harry Jr. and Linda and Raleigh to be adjusted by Mr. Dan Caffey to give each one of the 3 children equal acres. Mary Marlin, 11/20/96. Even though this survey was not allowed to be incorporated into the will, it is still evidence in the case. So we have a signed writing, the August 24, 2000 codicil, and even prior to that, this survey drawing, it even wrote down names as to which side of which tract were to be assigned to which child. So we submit that the trial court did not abuse its discretion in looking at it this way. This confusion with the partition statute, even the partition statute says that the judge has to determine the rights of the parties according to the respective rights and interests of parties adjudged by the court. To adjudge that by the court was he had to interpret it through the will. If you go by what the appellants are asserting, you throw out the will and you just go under a partition statute and ignore what the plain language was. We submit.
Counsel, let me before you get too far in, let me ask you the question again I asked opposing counsel. Farm property be divided in equal acres according to the division I've indicated on the survey. I mean, how do I understand a little bit about what you said about the drawing that had this marker, but how do we know what was the division she indicated on the survey?
Because it wasn't allowed to be incorporated into the will, I think we had to stop with the language equal acres. And how do you get equal acres? And that was the task of the trial court to try to determine.
Well, my question to you is, under the will, it says equal acres, divided in equal acres according to the division I've indicated on the survey.
That was the latent ambiguity, Your Honor. The latent ambiguity was because they couldn't, the judge didn't accept the survey that was presented. The ambiguity was, okay, she said equal acres. Now, how do we find these equal acres? So you're correct in that because the survey wasn't found, the exact borders couldn't be determined without going through the commissioners and determining what would equal acres.
How could the commissioners come up with the borders that she came up with?
They went under the, and the evidence of the survey that came in that was not incorporated, but is still evidence. She showed Harry Marlin Jr., which is the appellant's father, taking the left side of this property, Linda West the center, and Raleigh Marlin the right. Raleigh Marlin already having a house built over on that side. So it was determined that way. And then the commissioners were charged with drawing this up into equal acres based on their areas of expertise. And what they came up with was the drawing that was included in the final order for this case in order to follow her will as closely as possible. So the task was equal acres. This equal value thing never came in anywhere. There's been an argument made by the appellants that well, this 1975 will talks about share and share alike. When you look at that 1975 will, first of all property, at that time, it was Harry Marlin Sr. and Mary Marlin. When Harry Marlin Sr. passed, Mary Marlin became the sole owner of that property. She could do what she wanted to do with it. And what she did was she issued a codicil that said, here's how I want it divided, as supported by that prior survey. So this other part is dead. This part about they want to say share and share alike, that ended because that article never came into play. Or Article 1 of that 75 will came into play, not Article 2. And they the appellants want you to think that somehow this means that there's supposed to be equal value. That is not what has ever been said by the tester 6 herself. She said equal acres. And so
she said, I'm sorry, and I don't mean to want to sound like I'm arguing with you because I'm not, but I'm just trying to get you to help me understand. It says equal acres according to the division. I mean, maybe she drew it a completely different way than the commissioners did. I mean, how would we know?
Well, it's possible, but this is what we refer to as the latent ambiguity. To figure out what she meant, they had to have these commissioners come in and divide it. Equal acres is the provision that stands through it all. If just because we can't locate that survey doesn't mean equal acres went out the windows. Equal acres means equal acres and supported by
and my question, Mr. Scott, is what then was the point of admitting the 96 survey if it wasn't apparently it wasn't established that was the survey to which she was referring in the codicil. And so the court said, no, we're not incorporating it in there, but the court admitted it into evidence for what purpose?
It was the only writing that indicated to shed some light on this division that was signed, irrefutably signed by the testatrix. And it was and the locations of who got which parcel, like who got the middle, who got the right, who got the left. Was that determined by that survey? And then the commissioners went out and tried to make those equal acres? The survey in part, there was also testimony about which side was supposed to go to who during the case. Okay. And several drawings were submitted even by the other parties, but none of which was designated as the survey. But where did those surveys come from? Some came from Ms. Linda West. They were involved in discussions really between the siblings after Ms. Marlin passed, which But the whole idea, it seemed to be a general understanding among everyone, including the testatrix, that this left side, middle, and right side division was how she wanted it to be.
Thank you.
So we submit, Your Honors, that the Miss Marlin could do what she wanted to with the property, and that's what she did in her codicil. And we submit, the ruling, just because this survey wasn't incorporated into the will doesn't mean it was excluded from evidence. So, and as to this argument that was made, this will contest, there's nothing submitted to show this was in any way a will contest. There was no question that Miss Marlin had signed her codicil, signed all of her documents. It's just strictly a matter of interpreting. And we submit, much like the N. Ray Martin case that we cite, that this is a matter of determining what those equal acres would look like. So if you follow the appellant's argument and just say it's supposed to be equal value, there is absolutely nothing in any of these documents that said equal value. Ms. Marlin could have said something like that in her codicil. She could have said it on that survey prior to the date she executed the codicil. She did not. She said equal acres. They said, well, Ms. Marlin wanted to treat her children fairly. Her idea of treating them fairly was to give them each equal acre tracts of this farm. This farm has been in this family for close to 200 years. All she was trying to do was give each one the exact same size portion of the property. And that's supported by the items that were submitted so far as which side of the property is supposed to be is what the judge considered in reaching his decision. And we submit that there's no abuse of discretion in this case. He took a difficult task. He charged some commissioners with showing what would equal acres look like on this tract, because that was the guide he had. And so you cannot go strictly by a partition statute, especially when you've got a will that says what's supposed to be done. I'm surprised there's a statement in the brief of the appellant that says no person's last will and testament can overcome a statute. Well, if it's not against public policy, a testatrix is free to divide up their property any way they see fit. It's not trumped somehow by a partition statute, which we submit doesn't really govern in this case because you've got the guidance of a will. If you had no guidance from a will, then perhaps, but that's not what we have here.
All right, counsel, let's go back a little bit. I want to go back to the survey that the trial court found was insufficient proof show that it was a survey that the codicil referred to, correct?
I'm sorry, Your Honor, would you repeat
Yeah.
that?
The survey, the trial court found that there was insufficient proof for the trial court to find that this survey was the one that went with the codicil.
That's correct, because apparently it was kept separately by Mr. Raleigh Marlin, and because it was not found, quote, with the will, unquote, he submitted that it's not strong enough evidence to say that was the survey to be admitted with the codicil.
Okay, and what was the date of that survey?
11/20/96. It was some 4 years prior to the codicil.
And was there any other date on there? You said she signed it.
Yes.
Did the mother sign it?
She signed it, and
Did she date the signature?
yes, she dated the signature, and then she also wrote which tract was supposed to go to whom on the drawing itself.
What date's the signature?
11/20/96. So this
So
was it was in existence at the time that the codicil was later executed.
Okay.
So considering these things, Your Honor, we submit that we're restricted by going by the plain language. We can't sit down here and say, well, equal acres really means equal value. That is not what she said. It's not said anywhere in her documents. And we submit that the evidence that was presented at trial is supports the idea that the equal acres was the proper division, and that's what the judge was charged with, and that's what he did. We submit that in no way did that overcome, did that create some kind of abuse of discretion on his part. And so we submit, Your Honor, that we're not in a position here to go back and rewrite what she wrote, which apparently is what the appellants want to do. we submit there's absolutely nothing in these documents to support this equal value proposition, but there is plenty of evidence to support equal acres. And that's what was done in this case. And so we submit, Your Honor, that the way that the trial court divided this is the appropriate way. It's basically the only way with the tools he had at hand, and that these commissioners that came in there, there was an appraiser, there was a surveyor, and there was a real estate person. They looked at this whole thing and they said, what would equal acres out of this tract look like? That's what they did. There was no point in having some kind of an appraisal because equal value was not the standard of the testatrix. It was equal acres. And that's throughout these documents, it's equal acres. That was the intent. That was the understanding. And we submit, Your Honor, that that is the appropriate division, that the trial court acted appropriately. We submit that this appeal should be dismissed. We submit there's no abuse of discretion, and we submit that this is the appropriate treatment would be just to affirm the trial court's decision, and so that this estate that's really now been open for off and on for basically over 20 years can move on to its next phase. Thank you.
Thank you, counsel. We'll hear from the appellates in rebuttal. Excuse me, the appellants in rebuttal.
Thank you, Your Honor. I don't think I'll take all 5 minutes. There are a couple things that counsel brought up. The bottom line is that there's nothing fundamentally preventing the trial court from making the partitions both equal acreage and equal value. It might be hard, but there's nothing stopping the court from doing that. That didn't happen here, and there's a certain element of common sense that comes into play here. Linda, the executrix, testified that her mother wanted the children treated equally. So there is evidence in the record. That also.
Let me interrupt you really quick. Your argument, though, presupposes that the value of this acreage, as mom viewed it, was for these heirs to then sell it. So the value of the acreage was in the appraisal value of it. And that's what needed to be equal. But couldn't you, that's an assumption, because you could also say that to mom, the value of the acreage was the land itself. And her intention was not that her kids sell it, that it was that the kids continue to use it as however they want to as a family farm, but they each get equal portions of the land, not they each get equal so they can turn around and sell it and develop it. We just don't know what her intention was when all we know is she used words equal acreage.
And we don't know, again, what was in her mind when she wrote that, but also we've talked a lot about the development potential of some of the parcels, but the parties could want to continue to use it as farmland, and there are different characteristics of each of those parcels, just like my half acre in suburban Davidson County is not worth the half acre that this office building is sitting on. So even to continue to use it for farming purposes, the equal value analysis does come into play, because you can't farm on a portion that's encumbered by a gas pipeline or that's within the floodplain. So all of those considerations should have been included, and they just weren't. And the solution is to send it back down and have an analysis done by an appraiser of the value of each of these tracts. If they're the same, then that's it, right? If they're wildly different, which is what we suspect and what the posture of the appellee suggests, then they have to be modified, and the court has that ability. And a couple other things that opposing counsel brought up. He mentioned the abuse of discretion standard. The case that they cite for the abuse of discretion standard does not apply to this case. That was a case involving adoption rights for same-sex couples. That has nothing to do with this. All of the cases that we've cited indicate that this is a regular de novo standard of review. So I just wanted to make that point. Before I finished up with the point that if this is not a partition case, as Mr. Scott has suggested, then why follow the procedures of having the special commissioners appointed? And in fact, the underlying Chancery Court case was filed after the probate court case was administratively dissolved. So this when new life was breathed into this several years ago, it was reborn as a partition case, and then it was sent to probate. Again, this is why I think the probate court should have returned it back to chancery, so it's strictly a partition case. But the bottom line is, it did start, or at least it was reborn as a partition case after the probate was administratively dissolved.
Counsel, I have some questions for you. One, if we agreed with you, what would be the purpose of the codicil? In other words, if it's just a partition estate or a partition suit now, does the codicil have any effect?
I think
Or does it just go back to the 1975 will?
No, I think the codicil has effect.
What is it?
It's that we're looking for equal acreage, but there's nothing suggesting that we're not looking for equal value.
I understand your argument, but my question to you is, what effect, if any, does the codicil have? Or do you just simply go back to the language in the 1975 will?
I think you have to.
Where everybody shares and shares alike, each take 1/4 interest.
Obviously, I think that's the intent.
But that's in the.
I don't know that I can disregard the 2000 codicil in its entirety.
So what effect does it have if we agree with you? What does it do? How does it change, or as far as the farm property, how does it change what was in the 1975 will?
I think that it changes it in the sense that we should be aiming for an equitable distribution of acres in addition to value. I agree that that is a consideration.
But wasn't that what the 1975 will did? Equally share and share alike, each is to take a 1/4 thereof.
The answer is yes.
All right, so the codicil would have no effect.
Yes.
All right. Okay, thank you. Thanks to all counsel. We appreciate your oral argument today, as well as the briefs on this. Interesting case. Mr. Hibner, if you'll adjourn court until our next scheduled docket.
This honorable court is now adjourned.
Thank you, counsel. Y'all have a good afternoon.